My bank called me on a Tuesday morning at 9:12. Not the 1-800 number on the back of my debit card. Not the automated fraud alert system that sends text messages when something unusual posts to your account. Ellen Marsh herself, the branch manager at the First Federal on Garland Avenue in Knoxville, Tennessee, calling from her direct line, which I recognized because she had given it to me 7 years ago when I opened the business accounts and told me to use it if anything ever felt wrong. In 31 years of banking at that branch, Ellen Marsh had never once called me personally about anything. I was on the back porch drinking coffee and watching the fog come off the ridge when the phone rang. I picked up on the second ring. She said, "Raymond, it's Ellen. I need you to come in this morning. Are you available?" I said, "What's wrong?" She said, "I'd rather walk you through it in person. Can you be here by 10?" There was something in the way she said it that I want to describe carefully, because I think it matters. It was not panic. Ellen Marsh was not a woman who panicked. She had managed that branch through 2 recessions and 1 flood that had taken out the parking lot for 6 weeks, and she had done all of it with the steady, unhurried competence of someone who understood that calm is a professional obligation. What I heard underneath her words was something more specific than worry. It was the careful, deliberate tone of a woman who had encountered something she did not yet fully understand, and who was handling it with the kind of precision that means the situation is serious. I said, "I'll be there at 10. I finished my coffee. I fed the 2 dogs, a pair of old beagles named Hatch and Pepper that my wife Carol had picked out at the shelter in 2014 and that still slept on her side of the bed even though she had been gone for 2 years. I put on my jacket. I drove down off the ridge into Knoxville. Ellen met me at the entrance to the branch rather than having her assistant bring me to a waiting area, which told me something before she said a word. She brought me directly to her office. She closed the door. She sat down across from me, and she placed a printed document on the desk between us. Turned so I could read it. She said, "Raymond, a power of attorney document was filed with this bank 11 days ago. It authorizes a named individual to act on your behalf across all accounts held in your name at this institution, including your savings, your investment accounts, and the 2 trust accounts you established in 2019. She paused. "The document carries your notarized signature. The notary seal is registered and current. The individual named in the document has already submitted 3 withdrawal authorization requests, totaling $64,000. We have not processed them." I flagged it before anything moved. I looked at the document. My name was on it. Raymond Arthur Coffey, date of birth, social security number, current address on Ridgemont Drive. My signature at the bottom, or something close enough to my signature that I would have had trouble explaining the difference at a glance. The name on the document, the person granted full financial authority over everything I had spent 38 years building, was my nephew, Daniel Coffey. I set the document down on Ellen's desk with the particular deliberateness of a man making a decision not to react in the way the situation is asking him to react. I said, "Ellen, I did not sign this document. I have never been to any notary in connection with any power of attorney. Not in the last 11 days, not in the last 11 years. I work." She said, "I know, Raymond. That's why I called you before I called anyone else." I said, "Where was the notarization logged?" She said, "A mobile notary service out of Nashville. The seal checks out on its face. That's part of why it cleared initial intake." It was only when I looked at the withdrawal requests and the account scope that I pulled the original filing myself. I picked up the document again. I read it twice, the way I have read every document that has crossed my desk for 4 decades. Not for what it says first, but for what it assumes, what it is trying to make true by the act of stating it. It was authorizing Daniel to manage my financial affairs on the grounds that I was, and I am reading the specific language here because it matters, experiencing a significant and documented decline in independent decision-making capacity consistent with early-stage cognitive impairment. Significant and documented decline. I am 67 years old. I spent 38 years as a forensic accountant, the last 22 of them as a senior partner at a regional firm in Knoxville that handled financial fraud cases, estate disputes, and federal audit responses across 6 states. I have testified in federal court 14 times. I have reconstructed financial records from documents other people believed were destroyed. I know what fraudulent documentation looks like from the inside of its own logic, and I know how it fails. Daniel Coffey had filed a document claiming I was losing my mind, and he had done it while texting me 2 weeks ago to ask whether I wanted him to come by for Thanksgiving. I did not feel anger. I want to be clear about that because I think it changes the nature of what I did next. Anger is a reaction. What I felt in Ellen Marsh's office that Tuesday morning was something colder and more structural than anger. I felt the full shape of the situation become visible all at once, the way a set of fraudulent financials becomes visible when you know exactly which numbers to look at. I saw the architecture. I saw where it was built to fail. And underneath all of it, I felt the particular cold clarity of a man who has spent 4 decades doing exactly this kind of work professionally, and who understands that the person sitting across from a document like this is either a victim or an investigator. I had no intention of being a victim. I picked up the document. I stood up. I thanked Ellen. I told her not to process any withdrawal requests under any authority other than my direct, in-person instruction, until I told her otherwise. She said, "That was already my plan." I said I knew. I drove from the bank on Garland Avenue directly to the office of Margaret Callison, an elder law attorney whose firm was on the 4th floor of a building on Gay Street above a photography studio that had been there since 1991. I had been referred to her 3 years earlier by my estate attorney when I asked, in what felt at the time like a purely hypothetical conversation, whether he knew anyone in Knoxville who handled financial elder abuse cases specifically. He had said, "There is one attorney in this city I would trust with that work, and her name is Margaret Callison. She does not do scheduled consultations. You walk in." I had filed that information exactly where I file all information I expect to need eventually, which is in a place I can retrieve in under 30 seconds. Margaret Callison was 53 years old, with the economical manner of someone who does not waste language because she understands that language is the substance of her work. Her office had 2 whiteboards, both in use. She was on a call when her assistant brought me in. She held up one finger, ended the call in under a minute, and said, "Sit down. What happened?" I put the power of attorney document on her desk. I said, "My nephew filed a fraudulent power of attorney with my bank 11 days ago. The document claims I have documented cognitive decline. I have never been evaluated for cognitive decline. The document carries a notarized signature that is not mine. The notary seal is from a mobile service in Nashville. My nephew has submitted $64,000 in withdrawal requests against my accounts that the bank flagged before processing." Margaret looked at the document without touching it for a moment. Then she said, "How do you know the signature is forged?" I said, "Because I did not sign it, and because I know what my signature looks like under duress versus relaxed. And this is neither. This is a copy of a signature from a document I signed in 2021. She said, "Which document?" I said, "The deed of trust for the Ridgemont Drive property. My nephew helped me with the closing paperwork after Carol died. He was present when I signed." She looked at me. She said, "He copied your signature from a document he watched you sign." I said, "That would be my working assumption." She pulled the power of attorney toward her and read it in silence. She read it the way a professional reads a document that has been designed to deceive, which is slowly and from the bottom up. She reached the clause about cognitive impairment and stopped. She read it again. She set the document down and looked at the wall. Then she said, "Raymond, what your nephew has done constitutes bank fraud, fraud in the execution of a legal document, and attempted financial exploitation of a protected adult under Tennessee Code, annotated 716120. Each of those is a separate criminal offense. The mobile notary, if complicit, faces their own exposure. This is not a civil matter. This is a crime." I said, "I know." She said, "How would you like to proceed?" I said, "I want the power of attorney voided and the record corrected at every institution where it may have been filed. I want a formal investigation, and I want to be present when Daniel understands what he is looking at." She was quiet for a moment. Then she said, "Those are 3 achievable outcomes." She picked up her pen. She said, "Start from the beginning. Don't filter for what you think is relevant. That's my job." I told her everything. 43 minutes. She wrote 2 full pages and did not interrupt once. Here is what I told her. "My name is Raymond Arthur Coffey. I am 67 years old. I live alone in a brick house on Ridgemont Drive in Knoxville, Tennessee, in the house that Carol and I bought in 2003. The house where we raised our son Thomas. The house where Carol died on a February morning in 2022. In the chair by the window in the upstairs room, she had arranged specifically so she could see the ridge when the light came through in the afternoon. I will not spend long on that morning. What I will tell you is that the house changed after she left it. and I have learned to account for that change the way a structural engineer accounts for a shift in load-bearing weight, by understanding it exactly and reinforcing accordingly. Carol Ann Coffey, born Carol Ann Whitfield in Maryville, Tennessee, in 1958, had been a paralegal for 24 years at a firm in downtown Knoxville and was, in the professional judgment of every attorney who ever worked with her, better at the actual substance of legal work than most of the lawyers she assisted. She read documents the way a musician reads sheet music, not just for the notes but for everything implied between them. She kept a running legal pad on the kitchen counter where she wrote things she wanted to remember, case names alongside grocery lists, alongside things Thomas said as a child, alongside observations about people she had met. I found that legal pad after she died. I have not moved it from the counter. We had one child. Thomas was 41, lived in Nashville where he worked as a civil engineer, called every Thursday evening without exception, and had his mother's ability to listen completely before responding, which was the trait I valued most in both of them. Daniel Coffey was my nephew, 38 years old, the son of my younger brother Frank, who had died of a heart attack in 2018. Daniel had grown up in Cookeville and had moved to Knoxville in 2020, the year after Frank died, to, as he put it, be closer to family. He worked in insurance sales. He had a good handshake and a fluent way of making people feel attended to, the kind of social ease that reads as warmth but that I had learned over 3 decades of forensic work to look at more carefully before trusting. The pattern I noticed but did not immediately name began in 2022, the spring after Carol died. Daniel started coming by Ridgemont Drive more regularly. He helped with things around the house. He offered to review my investment accounts as a professional favor. He asked once, carefully, whether I had updated my estate documents after Carol's death. I told him I had. He asked whether I had considered a durable power of attorney given that I was now living alone. I told him I had that covered. He nodded and did not push. The questions were spaced carefully enough that none of them seemed like a pattern and all of them together were exactly one. Carol had said something to me in the fall of 2021, 3 months before she was diagnosed, sitting at the kitchen table with her legal pad. She had said, "Raymond, I want you to double-check where everything is and make sure Thomas knows where everything is and can get to it." I had said, "That's already done." She had said, "Do it again after I'm gone," and watch Daniel. I had asked her what she meant. She had said, "He's measuring something. I don't know what yet, but that man is always measuring." I had not understood the full weight of what she was telling me. I understood it the morning Ellen Marsh called. After I finished telling Margaret everything, she asked 4 questions. Did Daniel have any legitimate access to any of my accounts? No. Had I given him any documents during the estate process that contained my signature? Yes, potentially, the closing documents for the Ridgemont property. Did I have documentation of the conversations in which he had raised power of attorney and estate matters? I said I kept contemporaneous notes on every substantive conversation as a professional habit, going back to 1986, and that I had entries on every relevant exchange with Daniel from March 2022 through the previous month. She set her pen down. She said, "Mr. Coffey, I have handled 42 cases of financial elder abuse in this jurisdiction. I have had perhaps 5 clients walk in with what you just described." I said, "I was a forensic accountant for 38 years. Documentation is not something I choose to do. It is something I cannot stop doing." She almost smiled. The first call Margaret made from my presence was to an investigator named Roy Greer, who worked out of an office in the Old City District near the Market Square. He was 61 years old, wore the same canvas jacket to every meeting, and spoke in the unhurried cadences of a man who had learned that patience is the most productive investigative tool available. Margaret told me later that in 20 years of working with investigators, she had never once seen Roy Greer reach a conclusion before the evidence did. Roy called Margaret 6 days later. What he found was not a rushed opportunist's crime. What he found was a planned one. Daniel had over 18 months researched Tennessee elder law and the specific statutory requirements for power of attorney in the state. He had identified a mobile notary service in Nashville that had previously been flagged by the state licensing board for procedural irregularities, which in practice meant their record-keeping was loose enough to make verification difficult. He had obtained a copy of the 2021 Ridgemont Drive Deed of Trust through a public records request, a document that contained my signature across 3 pages. He had practiced that signature. Roy found the practice sheets in Daniel's recycling bin at his apartment on Cumberland Avenue. which is not where you put things you want to stay hidden. Roy also found that Daniel had contacted two other financial institutions where I held accounts, a brokerage in Oak Ridge and a credit union in Farragut, and had submitted inquiry letters asking about the process for third-party account management on behalf of an account holder with diminished capacity. The letters were sent under a slightly different version of his name, not different enough, and Roy found one more thing. A limited liability company registered in Chattanooga in September of the previous year, Coffee Estate Management Services, LLC, stated purpose: fiduciary financial services for family members with documented care needs. No clients, no revenue, no transactions of any kind. A clean, empty structure, waiting. I want you to sit with that for a moment, because I needed to. He had built the container before he built the fraud. He had registered a company to receive my money before he filed the document to take it. He had planned this the way you plan a project with a timeline and deliverables and an expected completion date. Margaret looked at Roy's report for a long time. She said, "He expected you to be processed before anyone looked closely enough." I said, "He has known me for 30 years. She said, "He saw what he decided to see. A 67-year-old widower, living alone, without Carol to catch it." I said, "Carol told me to watch him." Margaret said, "She was right." I said, "She was right about most things. I just needed her to be standing next to me when she was right about this one." Margaret looked at me for a moment and did not say anything, which was the correct response. "Now I have to tell you about Thomas, and I have to tell you about the night I called him, because it is the part of this story that cost me something I did not expect to pay, and that I have thought about more than the court hearing or the charges or any of the procedural events that followed. I called Thomas on the Thursday evening of the second week, 8 days before the hearing Margaret had scheduled on the motion to void the power of attorney. I told him to listen before he said anything. Then I told him everything: the document, the notary, the practice signatures in the recycling bin, the LLC in Chattanooga, all of it, without stopping. When I finished, the line was quiet long enough that I checked the call was still connected. He said, "Dad, are you okay?" I said, "I'm functional." He said, "That's not what I asked." I said, "I know. Okay comes after next Friday." He was quiet again. Then he said, "Did you know it was coming?" I said, "I knew something was coming. Your mother knew it more specifically than I did." He said, "She told you about Daniel?" I said, "She told me to watch him. She said he was always measuring." Thomas said nothing for a moment. Then he said, "She told me the same thing in January of 2022, a month before she was diagnosed. She called me on a Tuesday and she said, 'Thomas, if anything ever looks sideways with Daniel and your father's finances, you call Margaret Callison on Gay Street before you do anything else.' I asked her why. She said she had been doing legal work for 30 years, and she could tell the difference between a man who was being helpful and a man who was positioning himself to be necessary." He paused. I wrote it down. I still have the note. I sat at the kitchen table in the house on Ridgemont Drive and looked at the legal pad on the counter and thought about Carol reading documents the way a musician reads sheet music, for everything implied between the notes. She had seen this 2 years before I did. She had made 2 phone calls, one to me, one to Thomas, and she had planted the name of the right attorney in both of us, and she had done it while she was still well enough to be precise. I said, "Thomas, I need you in Knoxville on Friday." He said, "I'm already looking at flights." The Knox County Courthouse on a Friday morning is a working building, fluorescent and unhurried, the particular institutional beige of a place where serious things happen so routinely that the walls have absorbed the urgency and stopped reacting to it. Margaret met me in the hallway at 8:40. Thomas stood beside me. Ellen Marsh had agreed to appear in person because Margaret had asked her to, and she had said yes without any conditions. Roy Greer was there as a documented witness. Margaret had also subpoenaed the records from the mobile notary service in Nashville, which had, under legal pressure, confirmed that they had no record of conducting a notarization for Raymond Coffee on the date listed in the document. At 9:15, Daniel arrived with his attorney, a man named Gerald Pryor, who carried himself with the practiced ease of someone who expected a simple procedural motion. Daniel was in a good suit. He was groomed and composed in the particular way of a man who has calculated the odds and believes they are in his favor. He saw me in the corridor, and his expression shifted in less than a second. He recovered. He said, "Uncle Raymond." I didn't realize this was going to be a full hearing. I said, "It's a hearing about my finances and my legal capacity, Daniel. Where else would I be?" He said, "I hope you understand this comes from a place of genuine concern for you." I said, "I know exactly where it comes from." His attorney touched his arm. They went into the courtroom. The judge was the Honorable Patricia Warfield, 16 years on the bench, with a reputation for a particular intolerance for documents that could not withstand scrutiny. She reviewed the filings. She looked up. She said, "This is a motion to void a power of attorney and associated fraud allegations in the matter of Raymond Coffey versus an unauthorized filing. Counsel, please identify yourselves." Margaret identified herself as counsel for Raymond Coffey. Gerald Pryor identified himself as counsel for Daniel Coffey, the named agent on the challenged document. Judge Warfield said, "Ms. Callison, you have filed a motion to void on the basis of fraudulent execution. You have also filed a notice of criminal referral to the Knox County District Attorney. Summarize your evidentiary basis." Margaret stood. She presented it in 11 minutes. The absence of any notarization record. The practice signatures recovered by Roy Greer. The LLC registered in Chattanooga 2 months before the filing. The inquiry letters sent to my other financial institutions. The confirmation from First Federal that 3 withdrawal requests totaling $64,000 had been submitted and flagged before processing. She placed each piece of documentation on the evidence table as she named it. She said, "The account holder is present, is legally competent by every clinical and functional measure, and has never authorized, discussed, or consented to any power of attorney in favor of the named agent." Judge Warfield looked at Daniel's attorney. She said, "Mr. Pryor, what is your response?" Gerald Pryor stood. In the 3 seconds before he began speaking, I watched his face conduct a private inventory of what he had been told by his client versus what was on the evidence table in front of him. What crossed his expression in those 3 seconds was the specific calculation of a man determining how much of his professional credibility he is willing to spend on a position he can see has already failed. He said, "Your Honor, my client believed he was acting in his uncle's best interest and that the documentation process was conducted appropriately. In light of the evidence presented this morning, my client is prepared to withdraw the power of attorney filing and to cooperate with any inquiry the court wishes to initiate." Judge Warfield looked at Daniel for a long moment. Daniel was sitting very still. The suit and the grooming and the practiced ease were all still technically in place. They meant nothing. He was not the man who had walked into this courtroom 40 minutes ago. That man had a plan and a 2-year timeline and an LLC waiting in Chattanooga. This man had none of those things. The judge said, "Mr. Coffey." She meant Daniel. He stood. She said, "I want to be precise with you. A fraudulent power of attorney is a Class C felony under Tennessee Statute 716120. The attempt to access another person's financial accounts under fraudulent authority compounds that exposure significantly. I am granting the motion to void. I am entering a judicial notation in this record that the document was filed without the account holder's knowledge or consent, and that the account holder has been found fully competent to manage his own affairs. I am also directing this record in its entirety to the Knox County District Attorney's Office and to the Tennessee Department of Commerce and Insurance for review of the notary seal used in this filing." She paused. She said, "Mr. Pryor, I would strongly advise your client to engage experienced criminal defense counsel before the end of this business day." She stood and left. The room did the thing rooms do when something significant has just occurred, which is that every person in it became simultaneously and completely still for a moment, recalibrating. Margaret said quietly beside me, "That is exactly what needed to happen." Thomas put his hand on my shoulder and didn't say anything. I looked across the courtroom to the other table. Gerald Pryor was speaking to Daniel in a rapid, low voice. Daniel was sitting with his hands flat on the table in front of him, looking at the surface of the table the way a person looks at something when the structure they built has just come down and they are trying to identify which piece fell first. He looked up once, not deliberately, just in the involuntary way that a person looks up when they are trying to locate themselves in a room that is reorganized around them. Our eyes met. I did not look away. I did not say anything. I looked at him steadily with the expression of a man who saw this outcome from the moment he sat down in Ellen Marsh's office 14 days ago and who calculated every step between that moment and this one. Then I picked up my jacket and I walked out of the Knox County Courthouse into the October morning with my son beside me and Margaret behind me, and the voided document already entered into a record that was going to follow Daniel Coffey. For a very long time, the district attorney's office opened a formal investigation within 2 weeks. Daniel was charged in December with fraudulent execution of a legal document, attempted financial exploitation of a vulnerable adult, and bank fraud. He no longer holds an active insurance license in the state of Tennessee. The notary service in Nashville had its license suspended pending a broader audit of their records. Roy Greer told me that was 17 additional cases they had now identified, which was its own kind of story. Thomas drove up from Nashville for the first dinner after everything was settled. We sat at the kitchen table on a Thursday evening, and he brought a photograph I had not seen. Carol at a picnic in the summer of 2020, laughing at something outside the frame. The specific laugh she had when something caught her completely off guard. Thomas said, "I found it in a box when I was moving things at the Nashville apartment. I thought you should have it." I held it for a while. I put it on the counter next to the legal pad. He said, "She knew, didn't she? About Daniel." I said, "She knew what kind of math he was doing. She just wanted to make sure I had the right people around me before I found out." Thomas looked at the counter for a moment. "At the legal pad, at the photograph." He said, "She made 2 phone calls." I said, "She always said that most problems could be addressed with 2 phone calls if you made them to the right people." He said, "She was right." I said, "She was right about most things." We sat there until it was late. Hatch and Pepper slept under the table the way they always do, the way Carol trained them to do, because she believed dogs at a dinner table should be at the dinner table but not in anyone's way, which was also her general philosophy about most things. The house on Ridgemont Drive is held in the Carol and Raymond Coffey Family Trust. Thomas is the designated beneficiary. Margaret Callison is the successor trustee. My accounts at First Federal, at the brokerage in Oak Ridge, at the credit union in Farragut are documented, secured, and cross-referenced in a filing system that I could hand to a federal auditor at 9 in the morning and have them finished by noon. I am 67 years old. I walk 3 miles on the greenway along the river 4 mornings a week. I keep contemporaneous notes on every substantive conversation the way I have kept them since 1986. Not because I expect trouble, but because the probability of needing them over a long enough timeline is, as I can now personally confirm, not negligible. There is a man who spent 2 years measuring what he believed was a diminished and grieving widower living alone on a ridge in East Tennessee. What he was actually measuring, without knowing it, was 38 years of forensic documentation practice and one very good branch manager who made a phone call before anything moved. Carol used to say that the difference between a document that protects you and a document that harms you is whether you read it yourself before someone else defines it for you. She was a paralegal. She understood that language is where the real decisions live, not in the handshake or the smile or the precisely calibrated warmth, but in the actual words on the actual page and who put them there and why. I read the document. I knew what it was, and I knew what to do next. If this story stayed with you, drop a comment below and tell me where you're listening from. Tell me which moment hit you. If you're over 60 and living alone, share this with someone who needs to hear it. Hit that like button and subscribe if you're not already here. We put a new story up every week. Ring the bell so you never miss one.